currently out of the room. There were some additional issues. Mr. Baez.
Yes, Judge, at this time we would be moving for a mistrial based on the prosecutor entering into evidence two opinions from what would be called experts, or it's our position that they're expert opinions. First off, with Dr. Swanner yesterday, the state went into an extensive medical background history of his work history, and I realize that there's some of that you got to get into, but I think after having done that and eliciting testimony that they were extraordinarily high doses of fentanyl given to patients, and that was just one of two opinions that he had, over objection, been allowed to testify to. And then yesterday, after what seemed like a half hour of going into the medical qualifications of Dr. Roth, who hasn't seen patients since 2014, he was allowed to testify to, over objection, that they spoke with the family and advised them that the palliative withdrawals did not go as intended, thereby discussing and commenting on the intent of Dr. Husel and I presume the rest of the medical staff that worked on these patients. I think that those two cumulative opinions, that the defense was prejudiced by that. In addition, we were not given any expert reports by Dr. Swanner or Dr. Roth. Quite frankly, the first time I learned Dr. Roth's education and experience came yesterday, because we did not have anything, and there's nothing on Dr. Roth in the entire discovery, including no mention of no reports of interviews after having extensive meetings with police and police and prosecutors. So we had no idea that Dr. Roth was going to come in as an expert. I had no way of doing background checks on his prior trials, his prior opinions, prior depositions, as well as those of Dr. Swanner. And I think that with all of the motions and arguments that the state has made about our experts, that we should have been entitled to those of anyone testifying in a murder trial against Dr. Husel, that were going to render opinions as it related to their opinion, their medical opinions, and their medically based opinions, which the two aforementioned statements and testimony clearly outlines. And for that reason, we would be moving for a motion for mistrial on those two issues.
Mr. Zahn.
Thank you, Your Honor. The court ruled on this that not only were the questions appropriate, they were relevant and allowed to come into evidence. So I don't know if he's asking for a mistrial based on your rulings on that, Judge, but there was nothing inappropriate about anything that was asked Dr. Swanner or Dr. Ralston regarding their background, education, and training. It informs the jury about who they are and why they are making these decisions and why they're qualified to make these decisions. Mr. Baez, at least in relation to some of the people at Trinity, stated that the people that reviewed this had no clinical experience. I believe he made that in reference to Dr. Taco Bradley, an assertion that is not true, but regardless, making the point that the administrators didn't know what they were doing, and the implication is that they were framing Dr. Husel without basis for murder, is part of their argument, and we can talk about why they're qualified to do what they're doing. We can talk about not only why they're qualified, but why they are doing it, because we're medical doctors with clinical experience, and this was alarming to us. So it's entirely appropriate to ask someone's background and why they're qualified to make a statement. We're not offering them as experts under Rule 16K, But as this court has ruled again and again and again, they are qualified to talk about what they do and what their experience is and why they did things in this case. Not rendering a outsider's opinion like the 5 experts that we gave them 2 years ago in their reports. That's a different thing altogether. These people are doctors with clinical experience, and that based upon that education, training, and experience, they are allowed to comment on what they did in this case and what their practices are. And the court has ruled, like I've lost count of how many times you've ruled, that's entirely appropriate in this case. So we have done absolutely nothing inappropriate. It is prejudicial to the defense. Everything we do is meant to be prejudicial to the defense. That's what we do. So I don't believe that is a valid objection in this matter. It's not, but just because something's prejudicial doesn't mean it's not allowed under the rules of evidence. What we do is meant to, we're trying to convict them. That's what we do. So there is no basis at all for a motion mistrial on what Mr. Bias just said. Thank you.
Mr. Bias?
No response. I think I just made my record.
Okay. The court has been discussing these types of issues from day one, the difference between subjective and objective opinions. I've also given living instructions to the jury on similar issues, and including that issue. I feel it's fair that they can comment about why they did a certain act. Okay, it does not allude directly to the doctor, it just alludes to what they're doing. I don't think it's been prejudicial at all, so the motion's overruled.
Thank you.
Okay, we ready? Okay, Ms. Schaefer, please.
It's my phone. I keep hearing it. I don't even know where my phone is. I'm just going to turn it all the way up just to make sure.
I'm sorry?
We're talking to each other.
Talking about what I'm going to do this weekend.
That's the problem with this bell I'm in. We have a judges meeting at noon tomorrow to discuss how long this is going to be up. Emergency meeting. I convinced them to pull it off.
I have soccer dad duties this weekend, so it's
I'm glad all mine are grown, so.
How old are your kids?
Except I do have a grandchild coming in May.
I'm sorry, Judge?
I do have a grandchild coming in May, so I guess it restarts the
That
cycle.
restarts, that's right. In about 5 years. How old are you? 12. It's fun. It's fun.
by that time I'll have some comfortable lawn chairs for you, Your Honor.
You guys looking for something in the back there?
You got Dr. Ron?
Or? Okay, cool. Doc, come on down. He can come on down. A 2-lawyer escort. Wow. Two distinguished lawyer escort. Might as well have a seat and relax for a second. Are you okay, ma'am? Okay. You just look like you were bending over uncomfortably or something. Of course, I do have the reflection of the glass in the way, but the door is locked. Doo-doo-doo.